Welcome to the podcast for research, writing, and analysis called Introduction to IRAC, or CREAC, or CREXAC, the building blocks of legal analysis. You may have heard the terms used already in class. What is an IRAC, or a CREAC, or a CREXAC? This is merely a way to organize your legal analysis. Why do you need to use it? Because your audience has expectations. Remember, we discussed the busy audience, the lazy legal reader. Nobody wants to do the work of figuring out the answer to the question or what you're trying to say. It's a little bit like saying the punchline of a joke before the actual query of the joke. Will it make sense to the audience? For example, if I said to you, "Bye, son," you wouldn't really know what that meant. But then if I ask you the joke, "What did the mother buffalo say when her boy left for college?" "Bye, son," makes a whole lot more sense. In this same way, the legal audience has expectations. How do I use it? It's as easy as following the formula. You'll learn about the IRAC, CREAC, or CREXAC format. We treat it a little bit like a formula in the beginning, but then you're free to create and diverge from that formula in logical ways. Where is this IRAC formula or format located? In our class, it's going to be located in the memo that you're writing in the discussion section. Here's the memo that I passed out in class from your book, A Lawyer Writes. You will see that this memo has several different sections. We have the question presented, the brief answer, the statement of facts, and then finally the discussion section. This is where your IRAC, CREAC, or CREXAC begins. The first part of an IRAC begins with the I. The I in our IRAC format begins with the issue. This can also be stated as a conclusion. Let's look at an example. Let's say, for instance, that your senior attorney comes to you and asks if a burglary was committed by the defendant. You look at the burglary statute, and in our particular jurisdiction, the statute says burglary is the breaking and entering of another's dwelling with the intent to permanently deprive. Let's say the only issue in this burglary case is whether or not the victim, Ms. Smith's structure, was considered a dwelling for purposes of this statute. That could be answered in an IRAC. Now, if you were going to form an issue for that particular question, the issue might read like this: whether Ms. Smith's fort was a dwelling when it was in the backyard of her home, it had electricity, windows, and a door, and her children frequently spent the night in it. That would be an issue. It's one sentence, and it's really narrowing the question down for the reader. But this issue could also, in the alternative, be formed as a conclusion in one sentence. So, for example, Ms. Smith's fort was a dwelling for purposes of the burglary statute. You could even get more specific and make the conclusion that Ms. Smith's fort was a dwelling when it was in the backyard of her home, it had electricity, windows, and a door, and her children frequently spent the night in it. Either one of these is an acceptable way to begin the analysis. Both ways of introducing the issue serve to focus the reader down to the particular topic of this part of the memo. The next part of our format is the R, or the rule. The rule is comprised of the synthesized rule plus the explanation of the rule. First, the synthesized rule. The rule can come from a statute. It can also come from various case law. So if we have an ambiguous term in a statute, for example, and we don't have a clear definition, we would go to case law to try to figure out how the courts are interpreting that word. To do that, we'll look at several different cases, different precedent cases. But what if these cases are a little bit different? They have different outcomes, and we need to extract a rule that satisfies all of those particular outcomes. That would be called a synthesized rule. I like to use the analogy of a washing machine. So you've got all these different cases and these different outcomes. If you stick them into the washing machine and shimmy them around, you would eke out of the washing machine that synthesized rule. Another part of the rule is called the rule explanation. The rule explanation is merely telling the reader how you got that rule. And where did you get that rule from? You got them from the precedent cases. So you would explain those precedent cases to the reader, particularly if you're going to use those cases to analogize or distinguish to your own case. By explaining the cases, you would then bring out the facts, holding, and reasoning of those cases to inform the reader where you got that rule from. The next section of the IRAC format is the A, or the application section. This is the location where you would place all the arguments on both sides. It's the first place the reader should hear any mention of your particular client's facts. And you create the application section by taking the rule and applying it to the particular facts of our case. The final part of the IRAC format is the conclusion, or the C. This is briefly a sentence just summarizing or concluding your answer to the issue statement. Now, these IRAC building blocks can be used to create simple structures and eventually more complex structures. You're going to be using the same building blocks, the same IRAC structure, but have a different product. So first semester in Research Writing and Analysis, I'm going to be teaching you the simple IRAC structure. Now, we may start out with one IRAC in our memo, and then by the end of the semester you may be creating 3 IRACs in a discussion section of a memo. Now, second semester in your advocacy class, your professor may teach you more complex ways of using these building blocks. The structure may be a little bit looser and more free-flowing. For example, you may be condensing an IRAC or a particular issue into a 1-paragraph IRAC, or you may lengthen it and it may be several pages long. You may also use this structure in the future for your exams and other classes. Lawyers expect you to explain the law and then apply it to your particular client's facts. It even comes in handy on the bar exam for those essay questions.